What is grooming similar to Missouri law in Illinois?
Yeah, so in Illinois, they've got, it's kind of an interesting law, actually. So you can be charged with grooming for trying to, through sexual communications, or the statute itself is the purpose of the communication to elicit some form of sexual gratification or sexual response. And so you can be charged criminally for grooming if you have been expressly told that someone was underage, but also there is a line in the statute that says for what you believe to be someone that is underage. So, I mean, even if you are communicating in this day and age with AI, people do that all the time, and for whatever reason, this AI bot or chat bot, or now it's being utilized by law enforcement in their sting operations, but we have clients that are being charged, that have been charged just through communications with where there is no victim. But the question that the state's attorney has to present to the jury, and the answer that they are seeking, is that the defendant knew or believed that that person was underage. It doesn't. So it's.
Wow.
I have heard judges call it a victimless crime, because there is not a. It's not a real person. It is, but it's just based on what the defendant believed when they were the intention.
Yeah.
Whereas in Missouri, it's more so kind of what you see with Chris Hansen on like To Catch a Predator. You know, it's you take an overt act to go meet someone, you know, in a hotel room or things of that nature, and you show up and surprise, surprise, it's law enforcement. So the grooming thing is a very unique issue to Illinois, and that's why, you know, I had Josh answer that question.
Illinois does not require that you get in your vehicle and go try to effectuate some sort of meetup. It can be done without any effort to do. It can be based on the conversation alone.
Really?
Yeah.
Wow.
So that's kind of the stark difference I was mentioning.
That's a stark difference between Missouri and Illinois.